Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will learn about Coparcenary, composition and features, introduction and meaning, then difference with Hindu joint family, then incidence of Coparcenary and finally the conclusion. Let's begin with introduction and meaning. Coparcenary is a concept within the Hindu joint family focusing on a smaller subset of family members who share the inheritance rights to ancestral property. Traditionally, this unit included only male members who were lineal descendants of a common ancestor. It included only those persons who acquired by birth an interest in the joint or coparcenary property. These being the sons, grandsons and great-grandsons of the holder of the joint family property. After the amendment of 2005, a coparcenary in a Hindu joint family consists of a common ancestor and his male or female descendants from the subsequent 3 generations or an overall of 4 generations. Here, it is important to understand the difference between Hindu joint family and coparcenary. The concepts of Hindu joint family and coparcenary are central to Hindu law, particularly in the context of property ownership and family structure. The Hindu joint family is a broader entity governed by the Mitakshara and Dayabhag schools of Hindu law. It comprises members lineally descended from a common ancestor, including males and females. Under the Mitakshara school, the joint family is managed by a Karta, typically the eldest male, who holds significant authority in managing family affairs and property. The Hindu joint family is defined not by any legal contract but by birth, adoption or marriage into the family. And it persists until voluntarily dissolved by partition or death. In contrast, a coparcenary is a more limited body within the joint family, consisting of male members up to 4 generations from the same ancestor. The primary distinction lies in the rights over ancestral property. Under the Mitakshara system, a coparcenary is born with a direct right to ancestral property. The Hindu Succession Act 1956 codified these property rights, but it was the Hindu Succession Amendment Act 2005 that revolutionized the concept by including daughters as coparceners, ensuring equal rights with male members. Dear learners, now we will discuss various incidents of coparcenary. In State Bank of India versus Ghamandi Ram 1969 and Ram Awadh versus Kedarnath 1976, the court observed that the incidents of coparcenership under the Mitakshara law are: first, the lineal male descendants of a person up to the 3rd generation acquire on birth ownership in the ancestral properties of such a person. Secondly, that such descendants can at any time work out their rights by asking for partition. Thirdly, that till partition, each member has got ownership, extending over the entire property conjointly with the rest. Fourthly, that as a result of such co-ownership, the possession and enjoyment of the properties is common. Fifthly, that no alienation of the property is possible unless it be for the necessity without the concurrence of the coparceners. And sixthly, that the interest of a deceased member lapses on his death to the survivors. The doctrine of survivorship dictates that when one coparcener of property passes away, the surviving coparceners inherit the deceased share. It is important to note that the amendment of 2005 has abolished the rule of survivorship. In such a case, his interest in the property of a joint Hindu family governed by the Mitakshara law shall devolve by testamentary or intestate succession, as the case may be, under the Hindu Succession Act 1956 and not by survivorship. The interest of a Hindu Mitakshara Kopasner shall be deemed to be the share in the property that would have been allotted to him if a partition of the property had taken place immediately before his death, irrespective of whether he was entitled to claim a partition or not. The concept of notional partition envisions a hypothetical division of property as if a partition had occurred before the death of the Kopasner. This allows for a more equitable distribution, especially in cases involving surviving female heirs. The main incidents of Kopasnary may be discussed as follows. First, nature. It is by now well settled that Kopasnary under the Mitakshara school is a creature of law and cannot arise by act of parties, except in so far as on adoption the adopted son becomes a Kopasner with his adoptive father as regards ancestral properties of the latter. It does not arise from any agreement among the members, but rather from the operation of law. The Kopasnary is a fluctuating unit and its membership fluctuates with the increase or decrease in the number of Kopasners. Next is membership. A Kopasner is one who shares equally with others in inheritance in the estate of a common ancestor. A person becomes a Kopasner of a family by birth. In a Hindu joint family, a Kopasnary is made up of a common ancestor and his male or female descendants from the subsequent 3 generations, or an overall of 4 generations. Since Hindu law equates adoption with birth, children adopted in the family also become part of it as Kopasners or non-Kopasner members, as the case may be. Next is the principle of a common ancestor and his lineal descendants up to 3 generations. As discussed earlier, a common ancestor and his lineal ascendants up to 3 generations comprise a Kopasnary. Beyond this, any male relatives who are excluded could be included in the Kopasnary once the common male ancestor died, as they would now be within 3 degrees from the new common male ancestor. Other relatives, though part of the Hindu joint family, are not Kopasners. Next is daughters as Kopasners. It is pertinent to note that 4 states, viz. Andhra Pradesh in 1985, Tamil Nadu in 1989, Karnataka and Maharashtra both in 1994, introduced unmarried daughters as Kopasners at par with the sons. However, in the rest of the country, daughters became Kopasners at par with the sons after the amendment of 2005. After the coming into force of the Hindu Succession Act 2005, Act number 39 of 2005, in a joint Hindu family governed by Mitakshara law, the daughter of a Kopasner shall by birth become a Kopasner in her own right in the same manner as the son, and will have the same rights in the Kopasnary property as she would have if she had been a son. However, she shall also be subject to same liabilities in respect of the said Kopasnary property as that of a son, as was held in Ram Bilas Singh versus Uttam Raj Singh and others 2008. In the case of Vinita Sharma versus Rakesh Sharma and others 2020, it was determined that daughters have equal rights in the Kopasnary property, regardless of whether the father was alive or deceased at the time of the amendment of the Hindu Succession Act in 2005. In G. Koteshwar Rama and another versus Chakiri Yanadi and another, the court in the context of Section 6 of the Hindu Succession Act held that rights in the Kopasnary property among male and female members of a joint Hindu family are equal on and from 9th September 2005. the legislature has now conferred a substantive right in favor of the daughters, that by Section 6, the daughter of the coparcener shall have the same rights and liabilities in the coparcenary property as she would if she had been a son. Thus, on and from 9th September 2005, the daughter is entitled to a share in the Hindu undivided family property and is now a coparcener as if she had been a son. The Supreme Court relied upon its own judgment in S. Sai Reddy versus S. Narayan Reddy and others 1991, in which it was held that the Hindu Succession Act was a beneficial legislation and had been placed on the statute book with the objective of benefiting a woman's vulnerable position in society. Hence, the statute was to be given a literal effect. Then there are non-coparcener members. They are coparceners, wives or widows and descendants of any degree below the 4th generation at any given point in time. They have rights of subsistence in the joint family property, but are not its co-owners with the coparceners. What about illegitimate son? An illegitimate son of a lineal male descendant is a member of a Hindu joint family under the Mitakshara law, but he is not considered to be a coparcener. In Ranoji versus Kandoji, 1885, the High Court of Madras held that an illegitimate son does not become a coparcener by birth, that he cannot therefore demand a partition against his father's brother's sons of property held by the father in coparcenary with them, and that he is entitled to maintenance only. Let's discuss property rights of illegitimate children. The issues relating to the extent of property rights conferred on illegitimate children under Section 16 Clause 3 of the Hindu Marriage Act 1955 were discussed in detail in the case of Jinia Keating and others versus Kumar Sitaram Manchi and others 2003. It was contended that by virtue of Section 16 Clause 3 of the Act, which entitled such children's right to the property of their parents, such property rights included the right to both self-acquired as well as ancestral property of the parent. The court held that in light of such an express mandate of the legislature itself, there is no room for according to such children who, but for Section 16, would have been branded as illegitimate, any further rights than envisaged therein by resorting to any presumptive or inferential process of reasoning, having recourse to the mere object or purpose of enacting Section 16 of the Act. Such children are only entitled to the property of their parents and not of any other relation. The court held that in the case of joint family property, such children will be entitled only to a share in their parents' property, but they cannot claim it on their own right. Then there is birthright. A defining feature of coparcenary is the birthright to ancestral property. Male as well as female members acquire an interest in the joint family property by virtue of birth, and they do not need any formal conveyance to claim a share. Eldest coparcener as Karta. The senior most male member has the right to become the Karta. Karta is the senior coparcener who has not retired from the position and who is not disqualified by insanity or otherwise from social intercourse and responsible dealings with the world at large on behalf of the family. In Commissioner of Income Tax versus G.S. Mills, 1966, it was held that under Hindu law, coparcenership is a necessary qualification for the management of a joint Hindu family. A widow is not a coparcener. She has no legal qualifications to become the manager of a Hindu joint family. A widow of a coparcener cannot, therefore, be a karta of the joint Hindu family, consisting of 3 widows and 2 minors. In Mrs. Sujata Sharma versus Shri Manu Gupta 2015, the court held that the plaintiff, a woman, being the firstborn amongst the co-partners of the HUF property, would by virtue of her birth be entitled to be its karta. Then there is community of interest and unity of possession. There is a community of interest and unity of possession between all the members of the family. It is thus clear that the members of the joint family collectively own the Coparcenary property. Each member has an interest in such property, though his interest becomes definite on partition. Until then, it is an undivided interest. Then, Hindu undivided family. Hindu undivided family refers to Hindu joint family and not a Coparcenary. The expression Hindu undivided family used in the Indian Income Tax Act 1922 means a joint family and not a Coparcenary. Then right to claim partition. A rightful copartner making a valid partition wish gets instantaneously separated from the joint family and is entitled to a portion of its property to be calculated according to the structure of the coparcenary at the moment of his decision to separate. On his exit, the rest of the family remains joint and the remaining copartners together continue to own the rest of the property. Then, copartner's power to alienate. A copartner can alienate his share in the joint family property with the consent of other copartners. In the event of refusal of consent by other copartners, the remedy available to him is that he may ask for partition. Once he gets his share after the partition, he may alienate it. Another important point is fluctuating shares. The interest of a copartner in the joint family property is fluctuating, as it may increase or decrease with the death or birth of copartners in the family. The respective share of a copartner is determined only after the partition. Abolition of rule of survivorship. The amendment of 2005 has abolished the rule of survivorship. The rule provided that in the event of the death of a copartner, his share in the coparcenary property devolves equally among the surviving copartners. However, the position after the amendment of 2005 is that after the death of a copartner, his share does not devolve according to the rule of survivorship, but is deemed to be partitioned. Section 6, Clause 3 provides that on copartner's death, the coparcenary property shall be deemed to have been divided as if a partition had taken place. Let's discuss coparcenary property. The Mitakshara school recognizes two kinds of property that a male Hindu can hold. First, ancestral property, and second, separate property. Ancestral property, also known as coparcenary property, means a property inherited by a male or a female Hindu from his 3 immediate lineal male ascendants, that is, his father, grandfather and great-grandfather. In Rohit Chauhan versus Surinder Singh and others, 1966, the Apex Court observed that coparcenary property means the property which consists of ancestral property, and a copartner would mean a person who shares equally with others in inheritance in the estate of a common ancestor. One of the basic principles of Hindu law is that amounts earned with joint family property are money belonging to the joint family. In the case of G. Budanna versus IT Commissioner Mysore 1966, it was held that property of a joint family does not cease to belong to the family merely because the family is represented by a single copartner who possesses rights that an owner of a property may possess. Here we will discuss property in the hands of the sole coparcener. In the same case, Rohit Chauhan versus Surinder Singh and others, AIR 1966, the apex court observed that so long as, on partition, an ancestral property remains in the hands of a single person, it has to be treated as a separate property, and such a person shall be entitled to dispose of the coparcenary property, treating it to be his separate property. But if a son is subsequently born, the alienation made before the birth cannot be questioned. But the moment a son is born, the property becomes a coparcenary property, and the son would acquire interest in that and become a coparcener. The view that we have taken finds support from a judgment of this court in the case of M. Yogendra versus Leelamma N. 2009, in which it has been held as follows. It is now well settled in view of several decisions of this court that the property in the hands of a sole coparcener allotted to him in partition shall be his separate property, for the same shall revive only when a son is born to him. It is one thing to say that the property remains a coparcenary property, but it is another thing to say that it revives. The distinction between the two is absolutely clear and unambiguous. In the case of the former, any sale or alienation that has been done by the sole survivor coparcener shall be valid, whereas in the case of a coparcener, any alienation made by the karta would be valid only in the case of necessity or benefit of estate. Another important concept is of sub-coparcenary. The concept of coparcenary within a coparcenary is a unique feature of the Mitaksha school of Hindu law. It refers to the situation where there are multiple levels of coparcenary within a single joint Hindu family. This can occur when a sub-branch within the family forms its own coparcenary while remaining part of the larger family coparcenary. A sub-branch can form within the larger coparcenary when a member, say a son, gets married and has children, forming a smaller coparcenary within a larger family. Each sub-coparcenary maintains its own coparcenary property rights while also being part of the overarching family coparcenary. Dear viewers, let's conclude today's lecture. The concept of Hindu joint family and coparcenary form the backbone of traditional Hindu law, governing family structure and property rights. While a Hindu joint family represents a broader social and legal unit comprising all lineal descendants, a coparcenary is a narrower body, historically limited to male members who possess birthrights in the ancestral property. The Hindu Succession Amendment Act 2005 marked a significant shift by granting daughters the same rights as sons, aligning Hindu law with the constitutional principles of equality. This amendment not only abolished the survivorship rule but also ensured equal property rights for daughters, empowering them to demand partition and inherit ancestral property. Thus, coparcenary rights under Hindu law have evolved significantly, especially with the amendments and judicial rulings ensuring gender equality. While challenges remain in implementation, the legal framework now firmly supports equal rights for women in ancestral property, promoting a more just and equitable society. With this, we come to the end of today's lecture. Thank you very much.